Hi, everyone. Good to see we have a few people here. Sorry I was a little bit late. I think everybody should be used to that now. I'm always a few minutes late. I was just going over some things and wow, time flies. Time got away from me a little bit. Trying to pull up the oh, now I have my sound on. Hold on. Over some things and wow, time flies. Time got away from me a little bit. Trying to pull up the come on. Now I have my sound on. Hold on. Okay, there we go. Sorry about that. Amateur hour here over here. How's everybody doing? I hope everyone had a chance to read it. It looked really long. I can't remember if it was 52, 56 pages exactly, but the actual reply itself was only 12 pages. Now I was just going through the affidavits that are added. I just want to make sure I saw everything. Yeah, okay. This is all old stuff. All right. So, hi, Travis, Maureen, Renee, Sue, Jen. Thanks for joining me, everyone. Hey, Jennifer. Okay, I guess it's ready to get started. So I'm just going to go through this. I'm not going to read it, but I'm just going to go through it step by step and then talk about some of my thoughts and some notes. Hi, Julie. Hi, Kathy. So let's just start right at the beginning. First off, you can tell that Kathleen is, oh, Paul's live right now reading it. Okay, well, hopefully I didn't steal people away from Paul, and hopefully when they're done there, they'll come over here. I never know what's the best time to go live. I just do it. I think I said this last time. I just do it whenever works for me. So anyway, I was saying that Kathleen, if anything, you can tell that she's greatly offended by some of the things the state says. Questioning her integrity, saying that she did not do a thorough investigation, all the things that they said, what we remember from the response. Yeah, she didn't really take too kindly to that. And she comes out pretty much guns blazing just about how they overlooked, they have no problem overlooking things when it suits their purposes. Now, one of the first things she talks about is how the response essentially mimics their previous responses, which is, again, something we talked about last time, was that they didn't do it word for word, but they used the same words and just mixed them up a little bit for the same argument. And Kathleen rightly points out that you lost on those arguments 3 times already. What makes you think that this is any different? So she's kind of just ripping them for basically recycling their responses. Now, the first argument she makes is that the argument that Steve didn't conduct a reasonable investigation before filing his motion is completely meritless. Now, this is where, let's see. The first thing she mentions is just that the irony, she does this in a footnote, how she says that it's kind of funny about them accusing her of not doing any investigation when that's been a problem throughout the entirety of this case. Their lack of investigation, particularly when it comes to Bobby and the previous Brady violations she's brought up and the other previous issues and eyewitness statements that she's brought up about how it's pretty funny that they're accusing her of not doing an investigation, which I agree. I mean, it's almost comical coming from them. And then she says the state's argument appears to be based on its self-serving conclusion that Mr. Avery's counsel stumbled upon Mr. Slowinski and within 24 hours filed the pending motion to stay the appeal in remand. Okay, so this is the first thing that I kind of take issue with because she did it. She said in the motion, and I'll go back to the motion quick. The very first thing she says is on April 11th, a new witness came forward to Mr. Avery's current post-conviction counsel and attested to the following. She's saying that he came forward on April 11th, and we knew that the affidavit was signed on April 10th, so we knew that wasn't accurate. But so for her to say that the state's argument is a self-serving conclusion No, that's actually what she said. That is, I don't know how you read that any other way. But she's basically laughing at them for thinking that she just stumbled upon this witness and 24 hours filed a motion. But every indication is saying that's what she did. I knew that it didn't make sense that she didn't. I think we've all seen things on social media or things that have come out to prove that she knew earlier than April 11th. But that was just one of those things that I was scratching my head at, because we knew he couldn't have come forth April 11th. So it didn't make sense that she was saying that. So I don't blame the state for bringing that up. And her argument doesn't really work here, because that's exactly what her motion suggests. Again, whether that's going to matter or not, I doubt it. I doubt anybody's going to deny a motion over her putting a wrong date on it. Courts usually are better than that. And then she brings up some of the other previous evidence about Bobby, just about his story, and how she's pointing out how Bobby is a proven liar. Again, these are what she's saying, not my personal words, but this is what she's saying, that Bobby is a proven liar, and that he, made the comments saying that when he took a shower, he came back and she was already gone. But then when they talked to Brian said that's not true. He told me that he saw her leave, things like that. And then the fact that he said that he was sleeping during a certain part of the day, that she has now proven there were computer searches being done at those exact times, proving that he wasn't sleeping like he said he was. So she's bringing up those things. And then she also brought up the scratches on his back that Dr. Bloom refuted. Okay, so in this motion now, she's telling us that Sawinski first came forward to her on December 26th, 2020. So obviously that clears up one answer that we had. When exactly did she know about this guy? Now, that's when he first emailed them. Okay, that doesn't mean that Kathleen was aware of it at that time, because they always have a lot of stuff they have to go through. But these are the investigative steps that she kind of just lays out, arguing against what the state said. She said that she reviewed the email from December 26, 2020. She conducted an extensive background check, producing his previous addresses, phone numbers, job history, social media accounts, car purchases, criminal history, relatives, etc. Reviewed all the discovery produced by the state prior to Mr. Avery's 2007 trial, searching for any record of Mr. Sawinski's phone call to the Manitowoc County Sheriff's Office. And that's important. That comes out. She talks about that more later. She searched and corroborated Mr. Sawinski's statements based on other evidence. And that's what we were just talking about, some of that. And she talks about it a little bit more, a little bit later. She hired an additional investigator, James Kirby, who has done work for her on this case before, but she wasn't engaging his services at the time. And so she essentially hired him again to do an additional background check, to do more vetting on this witness using additional databases, is what she says. And then after they confirm what they believe is that he's a credible witness, they had a telephone interview with him on April 9th. So now we're getting closer to the date when she said that she had contact with him. And then after that, Investigator Kirby actually drove to Manitowoc to visit him. And then that's when they had him sign the affidavit. And Kirby says later in his affidavit that he actually hired another private investigator, I believe he said, in the Denver area, because they couldn't get a hold of him. The phone number wasn't working, or they couldn't get a hold of him, and they weren't having any luck. So eventually they hired a private investigator in Denver to track him down, or to give him a letter that Kathleen actually wrote. And that's how they finally got a hold of him. But he was in Manitowoc visiting relatives. So that's why he was able to talk to him then, because he was now in the area. Let's see. Okay, so here she's kind of taking a jab at them again with the reasonable investigation argument. Again, it's just kind of a nice jab where she's just saying that, again, you have a lot of nerve complaining about my investigative skills. Now, here's the part that is really what's central to this whole argument. The state is saying that she must detail the steps she took to verify the truthfulness of the pleading that was made in the motion. Now, we've already talked about the fact that that's not true. She does not have to give a detailed account. She does not have to give everything she has. And so the state's arguing that she had to provide that, and she's saying, no, I didn't, because it's work product. And I don't have to tell you everything that I know about this situation, and that the statute doesn't require it. So the question is going to be, again, and we talked about this, but was the pleading in the actual motion enough to give the Court of Appeals to make them want to grant it? Sorry, can't think right now. My head's all spinning. So that's the thing. Does she have enough? Did she significantly plead her case in the motion for them to say, yes, we're going to grant this, and send it and stay the case and remand it back to the circuit court? I know that I've said this before. My personal feelings are that even though I know she doesn't have to give everything, she doesn't have to give step by step. That's absolutely true. She does not have to do that. I still think she would have been better served to at least say just any line saying that she had vetted the witness, she had done some investigation, or even mentioning just that one line she said earlier about background checking his job history and everything like that. I think that would have been very helpful. She wouldn't have to spell it out, but I think it would have been very helpful if she would have just at least mentioned it to show that she had some investigation. Because the state can only argue what was presented in the motion. And all this stuff she's saying now, well, the state had no way of knowing that because she didn't present any of that. Now, that doesn't mean the state's argument is good. It's not. It's poorly argued because of the fact that they're drawing conclusions. They can't do that. They can't make assumptions. And again, Kathleen points out the irony of that, about how they're accusing her of not vetting the witness and not doing an investigation. And yet they provided no evidence whatsoever that they investigated him to prove that his allegations were false. So again, she's saying, you're not disputing anything on the merits of this. So how can you yell at me or basically accuse me of not providing enough information when you're not even doing that yourself? And you cannot prejudge a witness. That's exactly what the circuit court is for. And that's why it has to go to a lower court. The Court of Appeals is not a fact-finding court. Okay. It determines whether the law was appropriately applied during circuit court proceedings. If you want to investigate the facts and the credibility of a witness, that is done in the circuit court. So the fact that the state is trying to say that she needed to prove his credibility, that's not true. She absolutely didn't have to prove his credibility. That's what you have a circuit court for, and that's why you have hearings, because you want to provide more information. You want to get to the bottom of this. And as a side note, that already makes me nervous about this, because we know that Judge Sakevich has not exactly been quick to, give a hearing on anything, which has been where she's made mistakes. And so, it could be doing the same thing right now. So it was just really a stupid route that they took, which doesn't surprise me, because their arguments are sloppy. They are. Again, they pretty much took the wording from previous responses, even though they failed on those responses. They failed to persuade the court, yet they used the same arguments. They used arguments that essentially they just pulled out of their butt. They didn't have any leg to stand on as proving that this witness, there was any reason to think there was a problem with this witness. They had nothing to point to say, oh, well, this guy, blah, 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 that he has this, 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 and this. No, they didn't. But yet they're accusing her of not doing an investigation or being, sufficiently investigating, when she didn't do that either. So basically they're telling that she should have done something that they didn't do, which, hypocritical thinking is the whole backbone of this area, of this case with the state. Let's see. Yeah, so that's why I said that. Now in the footnote, this is on, what page is this? 7. In the footnote, she says, also, contrary to the state's false claim, which Mr. Sawinski's affidavit states quite clearly, Mr. Sawinski did not receive any reward, nor did he seek to receive any award. Okay. Now, again, I'm going to mention that I kind of have a problem with this one. Because again, if I'm going to be fair, I'm going to analyze it both sides. He didn't say that. Especially that second part. He did not say that. He said exactly, nothing has been promised or given to me in exchange for this affidavit. It says nothing about that he wasn't seeking any kind of reward, because that was a big question that we had, or at least I had, and I know other people did, was did he contact her through the tip line? Did he know about the reward? Now, on the reply, she included affidavits from him stating, or, text messages that he sent. I'm not interested in the reward. I didn't know about it until after this whole thing started. And if I get the reward, I'm going to donate to Teresa Halbach's family. Okay. Not buying that, but okay. Maybe he'll donate a little bit, but come on. I'm just saying that if you're just trying to sound good, that's something you say. I just don't believe it when people say things like that. But when she says that he stated quite clearly that he did not receive any award, nor did he seek to receive the award, that is not true. That is not an accurate statement at all. And it's certainly not quite clearly, because he did not say that. It is not evident until this filing that he has said that he has no interest in the reward. So again, I'm being fair. I have to point it out that that's not really an accurate statement. And then but then she goes on to make a really good argument. This is the thing that I know a lot of us pointed out and talked about, the ridiculousness of what the state was saying. And she says the state provides no explanation as to why a record of Mr. Sawinski's call would be produced in response to an open records request now, if evidence of the call was withheld in the first instance. And that's exactly what we're saying. This is a Brady claim. She's stating that something was withheld. So why would she, file an open records request for something that she's already been told has been destroyed? And that's where she really gets like super burn on these guys. Super burn when she says, when she provides the evidence, hello, I have already been told that they've been destroyed. Because that makes the state look ridiculous. As usual, they don't know their own case. They don't know their own investigation. They do not look at the documentation. They are so clueless about this case. It's ridiculous. If you look at all of the documents they filed in the Court of Appeals, it just shows that they don't know anything about this case, nor does it seem like they are interested in learning at all. And this just proves it, because their own department already informed her that these records have been destroyed. And yet, instead of looking into that, again, not investigating anything yourself, they're saying like, well, you should have filed an open records request. And that's wrong for a couple of reasons. Number one was that, again, she's not required to do that, to file a pleading in a motion. And second is because she already knew it didn't exist, that they destroyed it. So again, this is where the state does themselves no favors at all, because they are idiotic, just completely stupid. And some of the things they say, I think they think it sounds good, so they just put it in there, and it's so bad. I am always just blown away by how little they know about this case that they're arguing. It's crazy. And then she just goes into a few paragraphs or a couple pages maybe of this Bletch case. I'm not going to read through, or Belich case, Belich case. I don't know how to pronounce it, where she's essentially just telling them, nice try, but this has nothing to do with this case. It's not even on the same, point or anything like that. It's just, it doesn't apply, and it's not even close. So the second argument she's making is because the state disputes Mr. Thomas Sawinski's credibility, this cause must be remanded. And this is, again, what I was talking about before, about them being hypocritical because they have provided no information saying that there's any reason to question his statement. And the fact that, as I said earlier, fact-finding is not a mechanism in the Court of Appeals. That is not what they are there for. Fact-finding is for the circuit court. So she's kind of like, thanks, guys. You're making my argument for me because you're saying that this needs to be vetted. Well, duh. Where do you think we're going to do that? We need to do that in the circuit court. So she's twisting it on them and basically saying like, yes, thank you. You're making the same argument I am, that we need to vet this and we need to have a hearing to sort through all of this. And she does bring up, I think I'm getting ahead of myself here, but a little bit, but she does bring up a case. She says, due regard shall be given to the opportunity of the trial court to judge the credibility of the witness. And that's always true. It's always for a judge or a jury if you're in an original trial. But if you're on a post-conviction motion, it's up for the judge to decide if there's enough evidence to have a hearing. And then once you have the hearing, that's when the judge will decide whether this witness was credible. You have to provide evidence, and you have to try to, in the state would have to try to impeach him. The process is no different, even though it's post-conviction and there's no jury. The processes are the same. You have one side that calls a witness, the other side has to try to impeach them. And so for the court to, or for the state to just say, nope, he's not reliable, done. That's, again, it's ridiculous. It's absolutely ridiculous. And so I think it's kind of funny that I said she kind of just threw that in their face. Like, well, hey, we actually agree on something. The fact finding needs to happen. And that's where it goes. It goes to the circuit court for that. It doesn't stay in the Court of Appeals. She also brings up at that point some of the other affidavits that support what the witness is saying. She mentions Kevin Ramlow, and she mentions Blaine's testimony that he saw Bobby driving the car. So she mentions those things. And then, and this is where she says that Mr. Sawinski's credibility demands the circuit court's intervention for a credibility determination. And that's where she's saying the state's response merely substantiates that there's a conflict concerning his credibility, and it needs to be hashed out in the circuit court. And then the third argument is she's saying that Mr. Avery's motion is proper. And this is really where this is what is going to make or break the decision by the Court of Appeals, whether to decide her motion was sufficiently pled. She brings up again about 97406, because they're also saying that it was not, that he can't remand it at this point because briefings have already been done. And again, we've talked about this. I don't want to be too repetitive. But she brings up the 97406 statute again, and about how the statute says that everything must be raised in his original, supplemental, or amended motion. And that's to prevent procedural bar. And so she's saying this is still part of that case. And she mentions at some point, how the court ruled previously that it was best to send it back to the circuit court for fact finding and make sure it's included so that she doesn't run into a procedural bar issue. But as usual, the state's just saying like, well, you can just dismiss it and just file that, or you can wait and start over. So again, Kathleen just wants to make sure that this is what the statute says. This is what I'm trying to do. I'm not trying to delay this. I'm not trying to leave my client in prison any longer than he needs to be. But this has to go with this petition, so she's not procedurally barred. She also brings up Kyles versus Wheatley. I know nobody remembers this, but probably about 3-4 years ago, I did an entire video on Kyles. But essentially, the point she's making here is that when it comes to a Brady claim, a determination on whether Brady applies can be cumulative. So it can include all Brady claims. It doesn't have to just be on one certain claim. You can actually use them as a totality to make a determination that there was a Brady violation. And that's why I did a whole video on that case, because that case is actually very important, because that also goes into how trial lawyers have an obligation to do their due diligence with investigation. And there's some other issues. And that's a very important case in Steve's arguments. So, if you want to go find that video. And she just says that she has brought this issue in a timely manner. He does not wish to waive this issue. Duh, of course he wouldn't want to do that. Okay, so that's pretty much the end of the actual reply. And then she provides her own affidavit that goes through like when she first got the email, and then she actually included the email. Just talks about more of the investigation. And then here's where she talks about Larry Ledvina. I never know how to say his name. But this is where she talks about how she made an open records request for the dispatcher log related to Manitowoc County Sheriff's Office. And she said that she wanted any communications between Manitowoc Dispatch and law enforcement, as well as any private citizens. So that proves that she has asked for this exact information before. And then she got the email from Larry Ledvina saying, we do not have recordings from that time period. So again, that just strengthens her rebuttal to the state, saying that she should have filed an open records request because, again, and it makes them look stupid. It does. I'm just going to go back to that again, that it really makes the state look stupid because they don't know their own case. Whereas Kathleen said she poured over all previous discovery to make sure that this information had already been requested. And, the state could have easily done the same thing. They could have very easily gone through the discovery to see if this had been requested or not. But, wouldn't want them to, wear themselves out trying to work on this case. Then he just talks more about the investigation. She has financial documents. We'll go through that in a second. And then she talks about the Innocence Project email, and I'll get to that in a minute. And that is probably the most important thing in this reply, in my opinion. She goes into the dates again. She's just kind of reaffirming what she put in the actual reply. And then she mentions the reward again. And this is where she mentions his text message. So here's the email that he sent on December 26th. I have to make this bigger because, God, I can't even see it. He gives basically the same story, but here's where things get a little bit different. He says that he was delivering papers about 1, 2 a.m. We did not have a time before. So now we have 1 to 2 a.m. is when he was delivering these papers. And he then said, Bobby Dassey, an old man, and another old man were pushing the RAV towards the junkyard. No lights at all. I almost hit them. Pretty much the same up to that point about how him trying to jump in front of his car. And then he says, I didn't slow down. I waved and I said, paper boy, gotta go. Then he talks about Bobby having no shirt on, and the other guy had a scraggly beard. Now, he didn't say anything about a gray or long beard, just had a scraggly beard and seemed to be in his 60s. On the latest affidavit, I believe he said 50s, 60s. But he said, I did call police, and they said they would contact me. They never did. After season 1, I emailed an attorney of Stevens and no response. I've decided to reach out one more time as this information seems vital, especially after what I just watched. I live in Denver now, but I lived in Manitowoc for over 20 years. Okay, so that's kind of an important thing. There's 2 things in this email that stand out. He says a few days before he found the RAV, he was delivering papers. In his current affidavit, he says it was on Saturday, November 5th. And then the other contradiction is when he's saying that he called, this is the same. He said he called police and they said they would contact him, but they never did. He doesn't mention the female deputy, and he doesn't mention them saying we already have the guy or we already know who did it, whatever he said previously. So then let's see, I already talked about this. So then I'm going to move on to, she provides proof of him being a newspaper carrier at the time. She provides proof from a bankruptcy that he filed in 2006. To show that she did a background check on him. Not important. Okay, so now this is the request that he says that this is the email that he sent to the Innocence Project. I don't know if it shows where it says it went to the Innocence Project. That part might be just cut off. But he's saying this was to the Innocence Project. And he's saying he delivered papers for years, even though, okay. I delivered newspapers to the Avery residents every day for years. Okay, he said that. But now in his bankruptcy paperwork, he says that he was employed since September 2005, which is only a little over a month before the crime happened. So that's a discrepancy. And that I would want to kind of be sure about. And then he says somewhere between October 31st and November 5th. Okay, so again, we have a discrepancy on the dates. This is the oldest one. And this one, he's saying it's somewhere between the 31st and the 5th. In the next one, the first email to Kathleen, he says a couple days or a few days before, several days, I think he said, before November 5th. And in the most recent affidavit, he says it was Saturday, November 5th. Again, the state's going to exploit that. And honestly, if it was the reverse, it wouldn't be so bad, because usually people's memory goes from very specific to more broad. So if his very first statement had said November 5th, and then 15 years later, or however long later, he's saying, well, I think it was a couple days before, or it might have just been in between this time frame, that makes more sense. To go from broad to specific is not great. So this is another thing that will definitely play out. We're going to find this. So, and then he said that when he called the police, they didn't seem interested at all and said, thanks for the info. Never asked me to fill out a report or even ask for my name or my phone number. Again, that contradicts what he's saying now. He's saying now that they said they would contact him, which I don't know how they would say that if they didn't take his number, his name and number. So that's a little concerning too. So there are definitely discrepancies. Doesn't mean he's lying. It doesn't mean that, it didn't happen a certain way. It's just that it's something that the state is going to exploit if it ever gets back into the circuit court. And it's something that definitely has to be looked at. And the rest of this, this is just his affidavit again, where he said on Saturday, November 5th, I was delivering papers. And the second man appeared to be in his 50s or 60s, had a long gray beard, worn puffy jacket, had a larger frame. So he's adding more details. And this is where he mentioned, I called out Paperboy, gotta go, which he didn't mention before. Then he's saying he spoke to a female officer. I reported everything I have stated in this affidavit. The officer said, we already know who did it. And then he said, I provided my phone number and they said they would contact me soon. So he's changing his story. So we don't ever want a witness changing their story, ever. But you don't want them to lie either. But again, these are things that you have to look at if you want to weigh the credibility of a witness. These are important details, and it's not going to escape the state's notice, no matter how dumb they are. Somebody's going to point these things out to them. So those are the things that I took away right away, through reading it. And granted, I kind of always skim it and then I tried to read it again. So hopefully I didn't miss anything, but that's essentially it. So I've kind of given all my thoughts on it, I think. Let's see. Yeah, I talked about how, the state's stupid arguments, and where Kathleen made really strong arguments were things where I think they were a little iffy. And that I think the central issue here is going to be whether she sufficiently pled the motion, which is what I said after she filed it. So we still don't have an answer, but some of our questions are answered. So anyway, so does anybody have any questions? I haven't been really paying attention to the chat while I've been talking. And oh yes, the Innocence Project email is great, because at least, even though the details might not completely match, it proves that at a prior time, he did try to contact somebody with this information. This isn't like he just sprang up out of nowhere and gave Kathleen this information. So that is corroboration. It's not as ideal as if they'd had the original recording or some record of him calling the sheriff's office. It's not, it would be nice if Buting and Strang could have corroborated that he contacted them, but she said that Strang definitely did not have any emails from him, and Buting wasn't sure because he had changed servers and some of his emails were lost. So they don't have any record of him contacting them. So that would have been nice, but apparently they don't have that. Now, nothing has been said if Kathleen tried to get his phone records, Sawinski's phone records, because obviously if he can get his records from that back then, that can still corroborate that he made the call. Will they hold the dates against him? It was 25 years ago. Well, again, that's something that it depends on his answers. That's why you put somebody on the stand and you confront them with their inconsistencies. That's what you would do during a trial. That's the whole goal of an adversarial process. You try to find inconsistencies in witnesses' statements, and then you hope that you get them on the stand and that you can break them in some way and hope that you can discredit them. But the truth is, it doesn't mean they're lying. Memories change. If anybody knows, that is me. So memories change, memories fade. It said it's not the greatest thing, but it's not a disaster either. It's not like, oh, this guy's lost all credibility. No. It just means that the state has an opening to question his credibility. But they can't do that until they get to circuit court. So, hey, right now we're just wanting a remand. That's it. Small steps. So, okay, let's see. Was that conversation recorded, conversation record deleted along with others of that period? Well, yes, that's what they're saying. That's what they seem to be saying that the retention records don't require them to keep it past a certain amount of time. And so they destroyed all those calls, which is one of the things that's very unfortunate when you have a case that is open again so many years after the fact. And as far as cell phone companies, I mean, I know they got you can get old records. It just depends on what carrier they had and how long they retain their records for. But sometimes you can get old records. It's happened before. They're going to say witness influence from watching a documentary. They could try. Yeah. That would certainly be an argument to make, because hello, I mean, it's been all over the news. There two documentaries have been made about it. And so, yeah, I mean, of course the state's going to bring that up. So will he get the reward money, and will he actually donate it to the Halbach family? Well, obviously, I don't know. He only gets the reward money if his tip leads to an arrest and a conviction of somebody else, and Steve is freed. That's the only way he gets the reward money. So we're a lot of steps away from that. And whether he donates it or not, again, I don't want to be mean and say like, yeah, sure. But again, when you're trying to establish yourself as a credible witness, I can't imagine you saying anything other than, yeah, I just want to donate it. I don't want that money. And I take it with a grain of salt. Human nature, kind of goes against that. But there are very generous people in the world. So who knows? Aubrey says, I send brief emails for work all the time, then work out the details in person. That's the part. Yeah. And that's true. And that's why I said there could be a lot of reasons why there's a discrepancy in things. There could be things that you just didn't think about to say. I can't tell you how many times I've sent an email and then I got to send one 2 minutes later because I forgot to add something. It happens to me all the time. So this guy is expecting that this information is going to be enough for somebody to contact him. And then maybe he could give more details or clear things up when they talk to him. That's absolutely a possibility. And that's why I'm not saying it means anything. I'm just saying it's something the state is going to exploit. And ideally, you'd rather his story was exactly the same. But, we don't live in an ideal world. And, obviously we learned from this case, nothing goes 100% the way you want it to, for sure. This all sounds like it needs a day in court. Yes, and that's exactly the whole point. Yeah, if you guys asked anything earlier, you ask me again. So, because I don't want to scroll back through all those. That's just boring for everybody. So just ask me again. Perhaps she has the phone records, but it's not saying she has yet. Correct. She might. Or she might be working on getting them. We don't know. Kathleen never stops investigating. She might have times where things are slow, but she really never stops. Just depends on what she's got in front of her. And no, so she's never going to say, until this goes to a hearing, she is never going to stop and say, no, I know enough about this guy. I'm done. No, she's going to keep trying to find more. That's, until they get to a hearing, and it doesn't, nothing else matters at that point. You have all the information you could possibly get. Yeah, you're not gonna all of a sudden just say like, oh, I have enough. No, never. Did Stephen forfeit the wrongful imprisonment compensation because he was convicted of another crime? Yes. Well, he didn't forfeit it. He was paid out. It's just that he was paid not as much as he would have wanted. Most of it went to pay off his lawyers. Well, here, do they keep record on who worked answering the phone that day? Well, that's what Kathleen was asking for. She was asking for the dispatch logs, which would be that exact thing. The logs of who, maybe not necessarily recordings of the conversations, but just a log showing who called and their information. And they said they don't have that. Yes, and this is a good point too. The times he came forward previously, there was no reward offered. And that's what I'm saying, that even though he's saying now, like, I didn't know there's a reward, there's no reason to not believe that, because he did come forward before he knew there was a reward. So yeah, so that part of it, I don't doubt. There's no reason to question that he didn't come forth because of a reward and he didn't know about the reward. There's no reason to really doubt that. It's just after finding out about the reward for him to say that, I'm going to donate it all. That's the part that I'm kind of like, And it doesn't matter what he does with the money is insignificant. It means nothing to this case. It means nothing. Whether he gets it or not, I mean, they could try to say that he's doing this for financial gain. But again, he's got a very good case since he sent an email long before the reward was issued. So they don't really have a leg to stand on that one. Hi, Eric. Thanks for coming in. They have records for third and fifth. Okay, Kaboom, what are you saying? That the affidavit is old and he doesn't say he saw Bobby driving the RAV4? What did he say exactly? Because you know my memory. I know it's in here somewhere. The affidavit from Blaine. She attached it. I can look for it quick. Here's the Kevin Ramlow one. I want to make sure I say exactly what he said, because yeah, I don't remember things word for word. I don't want to be accused of saying the wrong thing. Here's the one. Okay, so let's see what he says. Sorry, I'm just trying to read through this quick. They're talking about the porn on the computer. Trying to get to that next part. He said, I saw Bobby on STH 147 in a bluish or greenish vehicle heading towards Michigan. And he said that Bobby was not driving his black Blazer. So yes, he said he saw Bobby driving what appeared to be a similar car, a similar color to the RAV4. He didn't say that it was a RAV4 or that it was even a utility vehicle. He just said it was a bluish or greenish vehicle. When did Kathleen take on Steve's case? In January, after Ma'am aired. Thanks, Ripper. I appreciate that a lot. Here, I'll put it up. There you go. Thanks for sharing your time with us and keeping the case alive. I really appreciate that. It's been weird this week being back and doing this, because it's been so long, and all of a sudden it's like now I've done a live stream every other day. While I'm on that subject, while I still have people here, I do want to mention that on Sunday, we are doing a 12-hour live stream, 9 a.m. to 9 p.m. in honor of Richard McAdam. And it's called Keep Talking Till They're Walking. Now, I have seen people think that this is Mammothon. It is not Mammothon. It has nothing to do with Mammothon. Mammothon is a totally separate thing. That's my thing. This was started by Paul Capaldi, and something that he and Richard's other friends all are coming together to do to honor Richard. But it's just like what it says. It's to keep talking, keep the case in the forefront, keep people talking until they're out, because cases tend to lose steam. Now, when this was planned, nothing was happening, and nothing was going to happen for a while, obviously. But obviously this week kind of changed that. So there's a lot of talk to talk about now. But prior to that, things were kind of quiet. So I just want to make sure that that it's not Mammothon. That's a totally separate thing. That's the one that I do. Paul is doing something different. So I want to make sure he gets credit for doing this live stream, and that it has nothing to do with me, or I'm just taking an hour, and I'll be on 1 p.m. on Sunday for an hour Central Time. So I just want to bring that up because I do know I've seen people saying that it was Mammothon. There is no Mammothon this year. Okay, let's see. This is important here. On YouTube, Blaine said it wasn't the RAV4. I do remember that now that you mention it. I think I don't completely take that as fact because Blaine was probably feeling a lot of heat from his family at that point. So I could see him wanting to backtrack a little bit. I mean, honestly, it doesn't matter what he says on a social media site. What he says in an affidavit is that's like, testifying in court. So let's see. Dean said he didn't receive an email, but Buting may have, as he changed servers and things may have been lost. No, probably not. If they're lost, they're lost. I don't know where you would begin. When you're changing servers, if stuff's lost, it's pretty much gone. Yes, it was definitely January 2016. I don't remember the exact date, but it was immediately after, ma'am. And there's a whole bunch there going on. Sandy has talked about it before, that she had been essentially stalking Kathleen Zellner for about 3 years, I think she said, prior to ma'am coming out, wanting her to take his case. Steve actually saw an episode of, I don't know for sure, Dateline 2020, one of those shows. And Kathleen Zellner was on it. It might have been about Ryan Ferguson. I'm not really sure. But anyway, Steve saw Kathleen on a TV show and he told Sandy, that's the lawyer I want. I need her. She's the one that's going to help me. And so Sandy did everything she could. And she's the one that said, quote, like, I stalked her. So she sent her a lot of letters. She sent her lots of information. She did everything she could. And Kathleen gets a lot of requests. Obviously, with her success, everybody who's wrongfully convicted wants Kathleen Zellner. She can't take them all. And on face value, Steve's case looked like a no-win case. And because people said, oh, she just jumped in it because of ma'am. Well, yeah. But that's because when she saw ma'am, she was like, I can't believe how ridiculous this is. And that's what made, like I said, you got to cut her some slack. She can't take every case. And so she has to go with the ones that are, has the most likely chance of winning. And this is a non-DNA case, which is very difficult. I do believe she thought there would be a DNA case. It would turn into a DNA case because of all the evidence that she scientifically tested, and that ended up not working out. So I think it ended up being more complicated than she thought. But yes, she did take it after ma'am. And that was, but she was contacted much earlier. She knew about the case, but I don't think she really understood it until she saw Making a Murderer. So it doesn't matter to me why she came on board. As long as Steve has an attorney fighting for him, that's all that matters to me. Could this lead? No. Could this lead to Kathleen getting access to the RAV over this? That's already been determined by the court, that they said that she will not be able to do any more scientific testing at this point, because that is initiating a new process. I think they use the word that that's initiating a new mechanism towards a new petition. That's not part of the current petition. So she would have to wait until after this appeal is done. If Steve loses, then she can try again to ask for the scientific testing and start the process over. Okay, hold on. I'm trying to read Ripper's comments here. Let me put up here. Hopefully this is the start of it. I know this was like a two-parter. Okay, so if Kathleen took over the case before all of those records were destroyed, there's a chance that she actually has a copy of that phone call and is using the FOIA request denial as bait. Well, she was told that they were destroyed in 2018, but we don't know when they were actually destroyed. I believe retention records are usually 7 to 10 years. So, I mean, it's possible they destroyed them after 7 years. I knew the statute at one point. I can't remember now, but it's in the state statute how long they have to keep electronic records or any type of physical records. I just don't remember what the exact number is. Okay, and I know you asked more. Okay, so, and is using that FOIA request denial as a bait to bait the state into going on the record and saying that the call never existed, which indeed it does. Is it possible she has the call and doesn't realize it? I guess. I mean, anything's possible, but I would be very surprised. And I you put your cards on the table now. I don't think you hold something like that back. If she had that, because that would pretty much guarantee that she could get it remanded. I mean, you don't really want to take a risk with something like this by not showing enough of your hand. And if she's saying that there's no way that they have it because they destroyed it, that means that she doesn't have it. Because if she said that, that would actually be that would question her integrity a lot. And I don't think she'd do that. It wouldn't be a smart move, is what I'm saying. I hope that answers the question. I think there are some other things, and sorry, it's scrolling by kind of quick for me. So, Eric, you're always late. Yes, you are, but at least you're here. Dean, yeah, that's what they were saying. Kathleen took the case January 2016. Yes. Yeah, I remember that too. That Blaine actually does have a YouTube channel that he used to use. Yeah, they're saying Blaine admitted he lied. And again, I'm not going to buy that because he had to be getting a lot of pressure at that point from his family. And so I could see him backtracking. Again, let's have a hearing and put him on the stand and force himself one. Either he's going to say what he said in his affidavit, or he's going to, if he says he lied, well, then, you run in that situation where he's either lying then or he's lying now, which doesn't make him a very credible witness. So that would hurt. But he's admitted to committing perjury. And he's committing perjury in an illegal affidavit. The statute of limitations on perjury from the trial is long past. The statute of limitations for committing perjury in an affidavit is not passed. So he would have to be really dumb to do that, to be honest. And it could come back to haunt him. Okay, so essentially Maureen's asking if the RAV was found on the 5th and there's records of the log that day because they used it in court and the witness says he called on November 5th, is there a chance they have the logs from that day? I'm sure that Kathleen's already looked through whatever they have. And I would say no. If they say it's been destroyed, then, now again, they can say it's been destroyed. It doesn't mean they're telling the truth. And that's why Kathleen was pointing out, well, you're telling me to ask for something they've already told me is destroyed. So are you suggesting that if I ask again, it's not going to be destroyed anymore? That's suddenly going to appear? Well, then thank you. You're proving the Brady violation right there. So that's why, Kathleen's saying this is a ridiculous thing to say because, hello, if I don't have it and you have it, then you withheld it. So either you don't have it or you do and you withheld it. There's really no way that she's ever going to get it now. Because they've obviously lied. That would be great, though. It would be great if it showed up and they can prove on top of everything else that they lied in 2018 about it being destroyed. That would be amazing. So when do you think this may go to the Court of Appeals? Well, okay, it's in the Court of Appeals. Last time that she did a stay and remand on the Bones issue, they ruled in just under a month. Now, this could take the same amount of time. It wouldn't surprise me if it's a little sooner, just because it's not as complicated of an issue as the Bones were. It's a matter of was this sufficiently pled, this motion. There's also the issue of procedure, because again, I've never heard of anybody, doing this, but I imagine it's the same situation because they still haven't decided the case. So even though it's been briefed, this is part of his petition that's in front of them. It applies to that petition. So I don't know why that would make a difference. It's not ideal, that's for sure. The court isn't going to be happy about it. But if it's sufficiently pled, then they have no choice but to remand it. Now, if they rule it wasn't sufficiently pled and that she didn't give enough to prove that this witness, that she corroborated anything with this witness, then, they might deny it. I can see it going either way, to be honest. But hopefully they'll rule a little quicker because it's a little more cut and dried, whereas the Bones issue was just a hot mess all over the place. So Was this call made from a landline or a cell? I do not know. I don't know if he said. I don't remember. What exactly is the remand? Like layman's terms, what does it mean? A remand simply means to send it back down to the lower court. The trial court is where the case starts. Okay. And that's where Steve was convicted. You file your first post-conviction motion in the trial court, and you have those proceedings. Steve was denied. Then you file your direct appeal in the Court of Appeals, and they look at that decision and make a decision, and Steve was denied. Once Kathleen, Steve tried to file a pro se post-conviction motion, which he was representing himself in the trial court, because those are always filed in the trial court. Direct appeals are in the Court of Appeals. Post-conviction procedures are in the trial court. So Steve was trying to do a pro se motion, and then that's when Mam came out and Kathleen came on board, and Kathleen dismissed that petition so that she could file her own. And that was all denied. And so once it's denied, it goes to the Court of Appeals. So what this is asking is to go back to the circuit court where you do fact finding. She mentions the trier of fact. That is what the circuit court, trial court, same thing. That's what they do. They listen to witnesses, they look at evidence, and they make a determination based on the facts presented of whether he should be granted relief. And if he loses, it just gets added to this appeal in the Court of Appeals. So that's all remand means, is that you're just sending it back to the lower court for further proceedings. That's it. And if it was in the Supreme Court and it's remanded, it could be remanded back to the circuit court, or it could be remanded back to the Court of Appeals. They would specify when they do that. Hopefully that answers your question. Maybe a little more thoroughly than you wanted, but hey, what the heck? Is it possible if they had them before trial? They didn't have them before trial. This guy's saying he contacted them after he watched Making a Murderer, but they for sure didn't have it before trial. I think they're pretty sure on that. Yes, I agree. Let's have a hearing. That's all Kathleen wants. I mean, and again, I tell everybody this every time, but it's important to remember this appeal is just about getting a hearing. It's not about him being, his conviction being overturned. It would be nice. They certainly have the power to do that, but they won't do that because there hasn't been any hearing on anything. They need to hear more. So that's all this is about. Once this goes back, if they grant this appeal and it goes back and Steve gets a hearing and he's denied, it's going back to the Court of Appeals again, but then it would be determined whether his conviction should be overturned or not. So that's what I'm always saying. Like, it's a long process. Any other questions? Still have a lot of people here. Just, I don't see any questions unless I'm missing them. But he called dispatch at the time that he saw the guys on the road on November 5th. Yes, that's what he's saying, but they don't have those records. So there's nothing you can do about it. And they're not required to keep them. They're required to keep them for a certain amount of years, but we're past that limitation. Let's see. The damn records retention statute should be revised. In the year 2018, records due for destruction should be scanned, saved electronically. Put that on the criminal justice revision to-do list. Yes. Yes, I agree. There's too many right now, especially in this day and age where there are new wrongful convictions and new exonerations every single day. They should revisit a lot of these retention records because of the fact that it's pretty common now. They know that it's common for people to be wrongfully convicted. The motion, we're not waiting for a motion. The motion is filed. This has been filed. Kathleen filed the motion. The state responded, and now Kathleen filed the reply. That's part of it. The pleadings are done and the arguments are done. It's up to the court to decide if they are going to grant the remand or not. That's where we're at. And I said that last time it took them about a month, but it could be sooner. It just depends on how long it takes them to get to it and how complicated they think it is. Okay, any other comments or questions? Well, I've been on for an hour now, so I can probably wrap it up. But again, I will be on Sunday from 1 to 2, and I don't have anything planned, so we'll probably talk more about this then. So think about your questions and join me. I will be posting my YouTube link in my group, in the Scales of Injustice group, probably Saturday. I'll be posting the link to my actual live. But again, it's 9 a.m. to 9 p.m. I don't know where all the links are going to be. I don't know how it's working in that respect, but I know that everybody's tweeting about it. So I think you'll find it if you're looking. Everybody will post their links. Thanks, Ripper. Okay, I'm just looking for last minute questions here. Any other? I'm just looking for question marks. I wonder if he said that, well, I think he watched the first Ma'am, right when it came out. It sounds like he was a little delayed because he said he just watched Ma'am 2 when he contacted Kathleen. So it sounds like he watched that not right when it came out. You guys are welcome. Oh, thanks. All right. So then I will talk to you guys on Sunday. I don't think there'll be any more news before then, but I hope to see you guys there. We're all going to just honor her friend and talk about how we wish he was here, but we're doing this for him. We're going to keep talking about this case. He would have loved this. Sorry he's not here for it, but we're going to keep carrying on in his honor. All right. I will talk to you all soon. Bye.